This time round, we're talking about therapeutic jurisprudence. Now, so far we've spent most of the term talking about restorative justice, and there is another slightly different or deeply different paradigm that's out there that we're going to look at this week and we're going to look at next week. And depending on the point of view that you end up with, it can either mean just a slightly different name for the same concept, or it can be a deeply different approach and different style of thinking, different way of thinking around alternatives to the conventional justice system. So, therapeutic jurisprudence. It's certainly more of a mouthful than restorative justice, and certainly involves some $10 words there that I guess are immediately an obstacle to engagement with the wider community. Therapeutic meaning a course of therapy or treatment based on a health model for improving a condition or a disease, and jurisprudence pertaining to ways of thinking about the law or legal philosophy. You could have called it something like therapy-based law, and it would have been a lot less pretentious and a lot more readable for other people, but in law we like to use long words. And I think there is, to an extent, part of the rift between these ideas is that this is sees itself as a more fancy, discipline-intensive legal and medical approach, whereas restorative justice is a bit of the community centre social worker kind of approach. So there's certainly, I can see there's a little bit of snobbery involved in therapeutic jurisprudence, and a little bit of gatekeeping in terms of we can talk about something in fancy terms to exclude people from other disciplines. That being said, I don't think that's all there is to it, and I think there's some interesting ideas involved in it. And there is also, I guess, some dangers and some problems involved in it. So fundamentally, we're talking about a very similar concept in terms of critique of the justice system and what the justice system does. Where restorative justice tends to end up with community-based systems of negotiation and settlement, therapeutic jurisprudence tends to push the offender into a medicalised treatment program. So it's less concerned with the victim, although victims get medicalised on their own, and it's more concerned with using medical treatment ideas to try and rehabilitate offenders and improve the lives of offenders, and therefore improve the lives of everyone else as the offenders become less likely to offend in the future. And therein can be a little bit of a problem with the approach, in that it can be seen as, from a certain perspective, as being soft on offenders. Offenders have gone out and done these terrible things. How come they get special treatment? Particularly in somewhere like America, where medical treatment is very expensive and it certainly isn't free for anyone. The idea of giving something that's a sort of a medicalised treatment to offenders offends the basic capitalist idea of let them fend for themselves. But there is also the danger, because under the traditional juridic system, you do your time, you serve your time, and you're out of there. Whereas the medical model is you get treated until you're better. So this is where I said there are some dangers. Is that this change in perspective can go from a sense of certainty, where you commit an assault and you get probably from anywhere up to 2 years, whatever, depending on jurisdiction, in prison or other options or whatever. You've got a sense of what's going on. Whereas for a simple assault, under this approach, it's at the moment it's still confined by those limits and by the sentencing limits, but there is a sense in which this philosophy could be used to justify a lifetime imprisonment for someone who's done something relatively minor, because they're still dangerous and they're still needing more treatment. So there is, and most of the proponents of this idea are aware of that, and are very cautious not to overstep into the total sort of dystopian idea of medicalising everyone who's guilty of crime. But it still remains a concern, right? It still remains this idea that you're fundamentally, if what you're doing is curing someone of their bad urges or their bad inclinations, that's a much more intrusive thing than just saying, we're going to confine you or punish you for a limited amount of time for the thing that you've done. Okay, so where did therapeutic jurisprudence come from? 1980s, a little later than restorative justice. And it really came out of the field of mental health law. And we are going to look at next week the notion of problem-solving courts. And the problem-solving courts are the most common implementation of therapeutic jurisprudence. So they're courts that are based around specific issues. So mental health courts, drug courts, Indigenous peoples courts. So rather than just having a generic court that deals with this and that and whatever, you say, well, there's some areas, and drug issues are a really good obvious one, where they're different from other offences. Someone who's possessing drug and using drugs is very different from someone who's assaulting people or anything else, although they may still end up doing that just because the drugs are criminalised. So we have a multidisciplinary set of court personnel. We attach the courts not so much to the prison system, although they still remain attached there, but we attach them to treatment and health systems. So the Neighbourhood Justice Centre, which I've mentioned a few times in Collingwood, does this very, very well in terms of its addiction practice and its drug practice. It does fit in fairly well with the notion that drug offences probably are not like other criminal offences. But we also acknowledge that even if you decriminalise drugs, there are still people with drug problems. So we probably still need some kind of social apparatus to deal with addiction. And if their addiction is causing them to do other things, to commit other offences, then this is a really good point at which we can intervene and try and give people options and give people a different way of going. So next week we're going to look at those different drug courts, mental health courts and whatever. Some places have done things around traffic courts too, but in terms of drunk driving, that's another area that there can be a focus. And this idea of specialty courts is, I think, one that's gaining traction, and I think there's been some discussion in terms of sexual offences, having specialty sexual offences courts. Now, with all of these, there's always a potential problem where someone commits a whole range of different offences, where it ends up, and like which court you end up within. You don't want to end up in the situation where you've got, conflicting courts. But ultimately, if someone's got mental health problems, mental health court is probably a better place for them, if it's run well, than a conventional court where the practitioners, the judge, doesn't have any specialised knowledge of mental health issues. They're just relying on their own observations. So mental health law was the primary source of therapeutic jurisprudence. It was coined by Wexler and Winnick, who as usual are in your notes. And they said that therapeutic jurisprudence is the study of the role of law as a therapeutic agent. It's the exploration of the ways in which, consistent with the principles of justice and other constitutional values, the knowledge, theories and insights of mental health and related disciplines can help shape the development of the law. So they're saying it's interdisciplinary law. Law crucially owns the area, because this often gets down to sort of pissing contests over fences and barriers. So law continues to own the area of criminal law and so on, but it brings in help from medical and therapeutic perspectives. Law has always been a real gatekeeper in terms of what's let in and what's let out, and you bring in people as expert witnesses, but you don't let that gets filtered through legal rules as to what's admissible and so on. We're all familiar with that from Bones, and I know talking to you guys that Bones is a popular show with lots of you guys, and the legal rules are informed by those other disciplines, but the law has always been very clear about, we let you in here, it's our house, we let you in here under barely tolerating you. So the idea of therapeutic jurisprudence is a much more, it's still owned by the law, but it's a much more even relationship, and the law is much more likely to take notice of the therapeutic perspectives. That being said, there is some issue in terms of which therapeutic perspectives are involved, and there certainly is a focus on behaviourism, and sometimes a fairly uncritical view on behaviourism. Now, that's possibly due to the fact that this is the era. 1980s was the high era for behaviourism when this notion was created. These days, I'm no expert, but I know behaviourism has fallen somewhat in its importance in the psychological disciplines, and there are other different approaches that are more mainstream in psychology, but there still is, I think, in therapeutic jurisprudence, which is really an unfortunately long word to have to keep saying over and over again, and if it stopped making any sense to you, it stopped making any sense to me as well. But the problem with the uncritical embrace of behaviourism in therapeutic jurisprudence is that, you know, psychology's moved on, and that there's this kind of time capsule of still trying to do the same kind of Skinner-esque, birds and pellets and that sort of approach that hasn't necessarily kept up to date. All right. So what are the differences? Because you could be forgiven quite easily for looking at this and saying it's just restorative justice with fancier words. And yes, from one point of view it is, because if you're being pragmatic and you're looking at some kind of outcomes, it has better outcomes for offenders and victims. They are very, very similar. In terms of how they are different, therapeutic jurisprudence is much more formal and places much more importance on the court, and particularly that idea we're talking about next week in terms of the problem-solving court. Whereas restorative justice is much more likely to have a process in court, and it's deferred or referred out to someone else to do the restorative aspect. So that's one really important difference. The notions of how stakeholders are constructed are also kind of different. Restorative justice is much more victim, offender, families, communities kind of basis. Therapeutic jurisprudence is much more the court and the other government agencies and the health system and the hospital system and the drug agencies. So it is much more agency oriented than community oriented. Generally speaking, there are of course everyone has a different model, so they're all kind of slightly different. The therapeutic jurisprudence model is again much more about this treatment model, which has some problems in terms of medicalisation. And, you know, the medicalisation of victimhood is a problem. So the medicalisation of offenders are a problem as well. On a surface level, you could think that, well, therapeutic professions are kinder and nicer than, you know, the justice professions, and have a, you know, you feel more cared for to be in a therapeutic process than to be in a penal process. But our history hasn't always suggested that, and we've certainly got some pretty horrific cases of what institutions have done in terms of mental health, in terms of drugs. So we do have to be very cautious that we do not uncritically embrace some of the worst aspects of the health services. You know, people who've gone to court have complained about the complexity of the court process until they've tried to go to a hospital and manage the administration of a hospital, and they realise actually courts are quite good and are quite reasonable and rational in terms of getting things done compared to a hospital. So there could be the danger of even more red tape and more bureaucracy in the medical style environment. All right, so what do we actually use these therapeutic jurisprudence models for? And this does tie in again to what we're going to be talking about next week, because these are involved in specific specialty courts. But there are certain things that it's been used for Again, different places, different models, so we can't ever say with any of these things that this is the way it's always done. But mental health is one of the big issues, particularly with the collapse of mental health institutions in the 1950s, and the release of people from those institutions into the community, which resulted in a lot of people who were institutionalized, I mean, as in were accustomed to living in a closed institution, who really struggled to operate in our open society and ended up in all kinds of trouble with the law, ended up in trouble just not necessarily because they were offending, but because they don't know how to live in the outside world, and they give ordinary people the creeps because they don't like seeing people who are different around them, and they call the police because there's someone who looks different who's hanging around, and they think they're probably going to be violent when they seldom are. So the closure of mental health institutions and the release of people into what's lovingly called the care of the community led to a whole lot of interactions between mentally ill people and the police. The use of things like vagrancy laws or more contemporary sort of homeless laws to lock up and contain people who go from being locked up in an asylum to locked up in prison, and basically a lot of confusion of how to treat people in these circumstances. And to be fair to the police, they're not exactly equipped to manage these situations, and they certainly want it in the 50s and 60s. So we closed those institutions for a good reason. If you want a great example of this, the documentary series American Horror Story Asylum does delve into this. Probably better real documentaries about it, but one of the sort of closing storylines of that series of American Horror Story was just how horrific the asylums were, and they were worse than any of the monsters or scary things that were in the sort of the horror part of the story. So we've sort of stopped one social problem and created another. We've never found a way of effectively dealing with people in court. So mental health, the use of therapeutic jurisprudence for mental health situations was a natural progression for where this got started. It then extended to drug issues, because clearly there are, without trying to simplify or oversimplify everything, there are strong connections between mental health use and drug use. Doesn't mean one is the other or caused by the other, but there are a lot of people who are affected by both. A lot of people who are affected by both end up involved in the criminal justice system. Pardon me. So the use of drug courts and addiction courts were a natural extension of this idea. It has been used in terms of domestic violence. I think part of it is due to the large-scale failure of the courts in terms of the domestic violence area. We still don't have, when we're getting better ideas, but we are still in the early stages of finding ways to intervene in domestic violence and to regulate it. There's a whole unit that we could do on domestic violence. There's a whole degree you could do on domestic violence, but the conventional, find the offender and punish them has certainly not been successful. So there is scope for that idea of using a more therapeutic approach to try and heal the person involved. Particularly, we know a lot of offenders with victims of domestic violence or witnessed domestic violence as children. And the other area in which therapeutic jurisprudence has been used quite often is the use of therapy as part of reintegration. And the important part of that is the personalised and individualised nature of therapy. See, our traditional ideas to rehabilitation are generally done en masse, because they're an extension of the education system. And a lot of things we do in education, we do give everyone exactly the same thing and let's just deliver it en masse. And the thing with rehabilitation is it's probably going to have every individual is going to have different needs, and therefore having the therapeutic experts and the therapeutic framework can be a lot more productive than just sending everyone off to, study some crafts. And then they'll, by studying crafts, they'll become better people. And then they'll get reintegrated into society. And it sounds like I'm being facetious there, but in the history of rehabilitation, the number of programs that were just, learn some crafts and keep them quiet, there was a really high percentage of them, and particularly for Indigenous offenders. When I was a visitor for a youth justice centre, there was so many of the interventions for Indigenous kids was getting them to sort of make strings of beads and things like that. And it's like, well, you'll learn to be more Aboriginal by making beads. It was a long while ago, but it was also extremely frustrating. So our history of rehabilitation programs aren't generally great. There was also a point at which it got sort of turned over to the TAFE sector, and it became sort of like learning how to do job interviews and things like that. I don't think is a problem itself, and I think getting people life skills is quite good. But again, it's about training packages that are delivered en masse the same way for everyone. And one of the things about the therapeutic model that's different is you go through an assessment process and a case management process where you assess individuals on what they need. Obviously, that's going to be a lot more expensive than mass programs of rehabilitation, but there's always that question of, is it worth the expense? Is it going to provide better results at the end of the day? There's a great scene at the start of there's a film called Getting Square. It's an Australian neo-noir film from late 90s, I think, and it's set on the Gold Coast. David Wenham's in it. It's a great film on a lot of levels, and it's written by a guy who's a solicitor on the Gold Coast who has first-hand knowledge of the kind of sleaze and thing that goes on. But there's a great scene with the parole board at the start where there's a guy saying, I've learnt to be better with. I've learnt to be a better person through rehabilitation. I'm always more courteous to my victims. I make sure I arrive at the crime scene on time, and basically, he's learnt. What he's taken away from the rehab things is how to be a more polite offender. It's a humorous scene, but it's quite a cool one. Anyway, so rather than providing these mass template kind of treatment models, therapeutic jurisprudence promises to provide something that's individualised. I think that is quite good. So next week we're going to wrap up this topic, and we're going to look at the drug court, those specific problem-solving courts, drug courts, mental health courts, and so on.